Helfand?
It please the court, Bill Helfand for Constable Christopher Diaz. This court is well aware the court may address the question of this qualified immunity appeal by looking at either element of the qualified immunity test, both of which require that the appellees disprove the presumption of immunity. And in this particular instance, particularly because the court has held that in First Amendment cases, there will, quote, rarely be a basis for a priori judgment that termination or discipline of a public employee violated clearly established constitutional rights. That's this court's opinion on Noyola versus Texas Department of Human Resources, cited at page 43 of the opening brief. It's probably best that the court, and certainly easiest, that the court analyze this appeal in terms of the question of clearly established law. Notably, in 2022, in Rogers versus Hall, this court again held that the question of clearly established law in the context of First Amendment retaliation claims is anything but clearly established. And so here, the question is whether the appellees met their burden to show clearly established law as to each aspect of Constable Diaz's alleged conduct, and the reason, therefore, under the specific factual circumstances presented by each appellee. And that's the easiest path to analyze the legal issues, I would respectfully submit, both as to the second prong, the clearly established law prong, but also whether there's a colorable violation of the law based upon those specific.
Is it oversimplifying to say that O'Hare is pretty clearly established in the areas that Anderson and Clark are suggesting?
Well, that would be a gross oversimplification to Your Honor's question and not relevant to this case. In fact, in the Bridges case, the problem with attempting to do that is that in Bridges, this court specifically held that O'Hare did not define clearly established law to the requisite level of particularity so as to create a bright line rule that could be applicable to any case. But of course, the other problem with the O'Hare case is it's not factually similar at all. In O'Hare, there was absolutely no question of O'Hare Trucking's refusal to support the mayor's campaign. Here, both of the appellees have acknowledged neither told Constable Diaz, well, I'm gonna take that back. Anderson acknowledges he never told Constable Diaz, as did O'Hare Trucking, I will not support your campaign. Clark alleges—
Well, let's slow down on that.
Yes, sir.
Because Anderson's at the fundraiser.
Anderson, I'm sorry, sir?
Anderson is at the fundraiser. There's a direct dialogue between the two of them.
That's Clark.
That's Clark?
Clark is the one who claims he told Diaz, I will not support, I don't want to work on the campaign anymore. I don't know.
Which is the plaintiff said, I'm not going to Topgolf. I'm going to go on my family vacation.
That is Anderson.
Okay, that's the gentleman I saw. That was a direct dialogue with Diaz, correct?
Yes, but the direct dialogue, Judge, was I can't be at the Topgolf event because I'm on vacation.
And the response from your client, at least alleged, is, well, don't put family holiday money on top of money to me.
That's the allegation.
Right.
There's no proof of that.
Don't we have to assume that's true?
Sorry, sir?
Don't we have to assume that's true on an interlocutory appeal?
You have to presume that that's that can be proven.
Yeah,
yes.
we can't re-examine whether there's a genuine fact dispute on that.
Sure. The question is whether that's a material fact as to the analysis.
Why isn't that material?
Sure. The court determines whether it's material, but yes, in terms of whether it could be proven at trial, the court presumes that could be proven at trial. But more importantly, that still doesn't speak to the O'Hare Trucking case or any other case from this court on the question of retaliation, because there's still no causal link between that and what Anderson complains of as the harm, which is his transfer, in which I think it was Anderson. Let me find, because I don't want to confuse the two of them.
Well, Clark was more indirect, as I remember. It's an immense district court opinion, close to 150 pages. But Clark's the one that you're saying, well, he only spoke to Hernandez. And the district court said it's a fair inference from the complaint that Hernandez had Diaz's ear. I don't see a problem with that either. And then we've got, then at that point, they get transferred, both of them to night shift. They have to work on weekends. The allegation is they get their car. That seems like retaliatory to.
Well, but the problem is, number one, those are allegations. There's no evidence of those things. And the court determines the reassignment in terms of whether it objectively rises to the level of some kind of punishment, not simply whether they perceived it to be punishment. And I'll come back to that, if I may, in just a moment. But more importantly, there is no evidence that would allow an inference that Clark's comments were ever conveyed to Diaz, to Constable Diaz. And Constable Diaz provides the only evidence that they were not.
I don't see how we could address that on an interlocutory appeal. It sounds like we're arguing about facts.
Well, I think that obviously it's a fact-dependent inquiry, and the question is whether the law is sufficiently clearly established that the constable is that the knowledge to Hernandez, to address Judge Higginson's question, can be imputed to Constable Diaz by some mechanism that the rules of evidence would normally not permit, because Constable Diaz denies it at the summary judgment stage. There's no evidence to the contrary. And so, to come back to your question, Judge Duncan, then the court would take that as established as well. There's no factual dispute there. But the more important question as to the clearly established prong here is there law that says that a statement of a decision not to support a campaign is itself First Amendment speech? There is no case like that in this circuit. There is no case in which this court has told officials that an employee who states that they won't support the campaign is protected under the First Amendment.
You're saying it is not clearly established that if an employee says, I will not support your campaign, and is then demoted or suffers some adverse employment action, that there is not clearly established law that that's retaliatory under the First Amendment?
That is correct. That is 100% correct.
So it's not clear that maybe you can do that, maybe you can't under the First Amendment. You're saying it is not clear under our law that if an employer does that, public official, you don't want to support my campaign, fine, you're fired. You're saying that there's no clearly established law that violates the First Amendment.
Right. As to the premise that you've just laid out, the one that exists here, that I simply don't want to support your campaign. There is no case in this circuit that says that. There are cases where one has run against their opponent, their employer. That's the Beatty case. There are cases where employees have openly supported another candidate, but there is no case where somebody has said, I just don't want to support your candidacy, ma'am or sir, and this court has ruled that violates, and that conduct that that person considered retaliatory.
It's certainly speech, right? Certainly speech.
It depends now. That's where we do get to the facts, Judge, and respectfully, the facts here are important. But Anderson confesses he never made the comment that we're currently hypothetically discussing. Anderson says, I never told.
We have to assume he did. Right?
I'm sorry, sir?
We have to assume that he did.
No, you don't have to assume he did, because he admits he didn't. The record is clear. Let me give you a record set on that. Anderson specifically acknowledges he did not tell Constable Diaz that he would not participate in the campaign. That's at 77:27 in the record. At 21,
Anderson says, I'm not going to be buying your meat and cooking your meat for you anymore. Anderson says, I'm going with my family and spending my money on a holiday instead of spending money on your campaign. That's my recollection, and this district court was very sedulous with the record. Are you saying his findings as to that are clearly erroneous?
Well, I think Your Honor is conflating two different statements at two different times. The Top Golf event, Anderson acknowledges that all he told Constable Diaz was that he would not be at Top Golf because he was going on vacation. That's at record 2191. And this all as it begins at line 11 through 2192. And as to the beef, the brisket, he told a subordinate, not Constable Diaz, I won't buy the brisket, but I'll cook the brisket. I don't want to pay for the brisket.
And maybe instead of us, because you have your memory of the record, mine, it's a big record, why don't you tell me where the district court erred factually?
The district court erred in mistakenly finding that there is clearly established law. That
So you're coming back to that legal point, and my response to you is I haven't yet heard a distinction from O'Hare, Supreme Court law.
Well,
The Supreme Court says you're protected if you refuse to politically align yourself, and then if your boss fires you for that refusal of political support, that's actionable.
but I apologize if I wasn't clear, Judge. Last year in Bridges, this court.
I'm talking about the Supreme Court.
I understand.
And you're saying there it was more direct targeting than here?
Not more direct targeting, more clear expression of a lack of support.
More clear expression of a lack of support.
The appellees here are claiming that this was compelled speech and that they were silent in the face of compelled speech. That's not what O'Hare said. O'Hare said.
Well, your brief is saying that they were silent. We'll hear from opposing counsel. I thought they said this is affirmative speech. It also is a First Amendment protected right to be silent. But I don't want to waste all your time with only 3.5 minutes. You had other points. Do you want to jump to adverse decision? What other aspects of argument do you want to highlight for us? Do you want to, and maybe I'm interested in your arguments about the sham affidavit rule as applied by Judge Miller.
Well, let me just, I do want to point out, because I'd be remiss if I didn't answer Your Honor's question, that this court specifically said I'm sorry, I said Bridges, it was Rogers, Judge, in the Rogers case.
Rogers v. Hall.
Yes, in Rogers, this court said, quote, O'Hare does not define the contours of the right in question with a high degree of particularity, which is the test of immunity. And so I appreciate that was the Supreme Court, but the Supreme Court didn't purport that it was defining it with a high degree of particularity. They were defining it in a more general sense. But I appreciate the opportunity to move on, because I would like to address a couple other points in the brief time that I have. It is not the appellant who is claiming that the appellees assert that it's compelled speech. Appellees made that argument to the district court. They argued this is compelled speech, and yet.
Why don't you jump to the sham affidavit and also to the adverse decision question? Both those.
Well, as to the sham affidavit, the district court erred in that the affidavit is not a sham affidavit because it doesn't provide alternative facts to that which was testified to. It addresses a question that the constable was not able to recall at the time of his deposition. And so that was an unnecessarily punitive ruling. But again, I don't think it's dispositive of the issue before the court, because as to the second prong of immunity, both as to the speech element and the adverse employment element, the appellees don't present case law that would have told Constable Diaz that reassigning these gentlemen, who are in a law enforcement agency constantly reassigned, as the unrebutted testimony of Chief Deputy Brady established, is punitive simply because they felt so. And this court has made clear that in order to claim a constructive discharge, one of the things that an employee must do is bring to the employer's attention that they think that it's punitive and give the employer the opportunity to respond. Lastly, in that vein, as Judge Higginbotham explained in the Oscar Renda Contracting, Inc. versus City of Lubbock case, cited at page 41 of the brief, the appellees don't even address the Mount Healthy issue, which again is the issue that Chief Deputy Brady, as an expert, testified to, which is that these types of reassignments are common. In fact, not only did neither of these individuals bring their dissatisfaction with the assignments to the constable, which this court made clear is required under Haley versus Compressor LLC at page 38 of the brief, but the evidence, the undisputed evidence, is Clark worked that supposedly objectively intolerable assignment for 9 months without complaint. before he resigned about the
This is
same.
as to constructive discharge. You're separate. What's your best case that shifting people to night so they lose a car allowance as alleged and they lose weekends is not an adverse decision?
Sure, Judge. It would be the Alvarado versus Texas Rangers, cited at page 33 of the brief, in which the court said the test of a transfer of employment action is objective and must evidence serious harm, and personal preferences, assignment preferences are insufficient.
Okay, thank you. You save time for rebuttal.
Thank you very much. My name is Scott Poerschke. I'm here for the Clark and Anderson. If it may it please the court. I think the court's correct that one of the issues that I had when responding to this brief was when looking at it and going over all of the arguments, that 90% of it just sort of argues that the facts, that Judge Miller got the facts wrong. And so the law sort of indicates that it's very clear. Case law says that this court lacks jurisdiction to review the genuineness of a fact situation, only the materiality. And so the way that the brief is phrased, and it goes through all the summary judgment standard, it's just it basically asks this court to go back beyond what Judge Miller decided on those facts, on the evidence, and it asks for the court to reevaluate that.
What is the clearest speech that each man gave that makes for an actionable First Amendment retaliatory? So what did Anderson say to Diaz directly or indirectly? What did Clark say to Diaz directly or indirectly? Or is he right that it's just a silence case?
So what it was with Anderson was at two events. There was a Topgolf event and then also a barbecue event. So at the Topgolf event, there was actually it wasn't at the Topgolf event. It was at an event at this restaurant called Spanky's. And what happened was that was a DS campaign function. And as Judge Miller had indicated, at that campaign event at Spanky's, DS conducted a roll call at that meeting and asked if anyone supported DS and encouraged the attendees to borrow money if they did not have the funds to support him. So that meets the element of what would be a demand versus Jones versus Collins, where a demand is made for political affiliation, demand is made for political support. Then in response to that, Anderson refused, and he communicated that idea. He told Diaz that he's not going to the Topgolf event because he wanted to take his children, take his family to Disney World. So that's the second part of the analysis. That's the actual speech that was communicated to Diaz. And then additionally, which is really not contained in Diaz's brief, was the district court, Judge Miller had found that there was an expression of displeasure where Constable Diaz said, well, it's nice that you have money to go on vacation, but not going to my Topgolf event, and it would be nice to have money to go on vacation. So that was the event at Spanky's. Then we get to this event number 2, where it was this barbecue event. And prior to that, there was an employee by the name of Jessica Duran. Now, one of the things that's left out of Constable Diaz's briefing was that Judge Miller found, he said specifically that Jessica Duran advised that this was something Diaz wanted. And he wanted Anderson to support for that barbecue event and to cook that brisket and ribs. Then, again, similar fact situation, Anderson then refused. He communicated that idea. He told Duran and others at that meeting that he would not be giving any more money to Diaz for anything, and his family wouldn't be attending the party. So those are the two events with Anderson. Clark, similar idea, where Clark was a member of this community outreach division. He attended various meetings where Diaz made demands for support. Then he refused. He communicated that idea on October the 3rd, 2018. Clark told Hernandez, that was the individual the court's already pointed out that had the constables, and I believe the words were, had Diaz's ear, as Judge Miller found. And he communicated that idea. He said, I no longer desire to participate in the Diaz campaign. And again, I think they argue with the factualness of reporting it to Hernandez, but the district court correctly found that Mr. Hernandez had Diaz's ear, obviously relaying that refusal to speak directly to Diaz himself. So those were sort of like the campaign events that were discussed.
The emphasis today has been, even under those facts, there's no clearly established law, and in particular, we've made clear that O'Hare doesn't stretch to that in Rogers versus Hall.
Right. There was I looked into that. Please correct me if I'm wrong. I looked at Rogers versus Hall, and that quote about that O'Hare doesn't define, I didn't see that in there. I might have been incorrect on that. One of the things, though, if you look at Rogers versus Hall, that case talks about the ordinary job responsibilities, and it's very clear that the standard in terms of the clearly established law is that the clerk in this instance, because he's the one that was involved in the Texas Rangers investigation.
So that all goes to the lane question. And
correct.
We haven't fully embraced lane and ordinariness. But you couldn't find the quote that was offered to us that...
No, I didn't. I looked for that because I noticed that it looked like it was a combination of...
Why don't you tell us what your best circuit authority is fitting the facts of this?
On this issue of lane?
Not on the lane issue. That, to my memory, did not come up in argument.
Okay.
The issue primarily was, is there any clearly established law that would say this type of conduct is retaliatory under the First Amendment at all?
Yes. So again, the case that the district court relied upon was O'Hare versus Northlake, that a state may not condition public employment on an employee's exercise of his or her First Amendment rights, and those rights include the right not to financially support a particular candidate. Then you have to have a demand. So the Judge Miller had noted silence in the face of a legitimate demand for speech is subject to First Amendment protection. That comes under Jones versus Collins. And then additionally, when you have that sort of issue about silence, then you have to have an outward manifestation. And as Judge Miller noted, under well-established Fifth Circuit law, there must be some outward manifestation of the allegedly protected First Amendment activity. That's Jordan versus Ector County. There was a discussion of Stedman versus Texas Rangers. That was a case where the plaintiff had never said anything about the political organization. There were some allegations that the plaintiff was a liberal or something along those lines, but that was never actually communicated, right? And so you have to follow that pattern of those cases when reading together, and I believe the facts support that as Judge Miller determined. Does anybody have any other questions?
Well, yeah, why don't you speak? I mean, shift changes aren't always actionable, adverse decisions.
Correct.
So why do these shift changes, the transfer, rise to it? And is your best authority the Click case you cited?
Yeah, Click versus Copeland.
Right.
Diaz
In that case, they were shifted all the way from sort of law enforcement to becoming jailers.
Correct. They were jailers. Diaz indicated in his briefing that the transfer in Click was to a non-law enforcement position, but I looked at that and it was to a jailer position. That position was considered to be a less desirable position. And so when looking at the facts that the district court looked at, Judge Miller looked at working nights with a increased risk of bodily injury, loss of weekends off, loss of car allowance, supervising fewer employees.
Only Anderson, right? Or
Correct. This is Anderson. And then the district Judge Miller also considered the affidavit from Mike Chrysler, who was the patrol division commander, where Mr. Chrysler indicated that new and inexperienced officers were routinely assigned to patrol division. There was that increased risk of bodily injury. There's calls for service in the field were more of a instead of an investigatory type situation, a supervisory type role of which Anderson was in, he's more put into sort of just being a regular patrolled officer, a uniformed officer. Mr. Chrysler indicated there were inconvenient duty hours and days off, wearing an uncomfortable uniform with protective gear and weapons, ununiformed.
Step further, for Anderson, constructive discharge?
All right, so that was Anderson. Clark had some of the factors. He did not lose his car allowance, however, but Judge Miller had found that Clark was working nights with the risk of bodily injury. Judge Miller found that Clark did not supervise fewer employees. They also considered the affidavit of Mike Chrysler. Now onto the question of the constructive discharge. The case on that one was Brown, and the consideration of the Brown factors. This was were transferred to a less desirable position, as already established when moving from the supervisory role to patrol. Judge Miller noted again that Anderson was going to lose his car allowance. Anderson also advised his supervisor that he could not safely perform the new position because he could not see it at night to drive. And Anderson was told that Diaz that he would need to find a new job, and found blank job applications on his desk. There is some argument about that Anderson didn't reach out or attempt to file a grievance or something along those lines. But Judge Miller had found that there was a meeting with a county employee by the name of Nick Lykos about the events that were taking place. And then Judge Miller indicated that he found that there was no grievance coordinator at Precinct 2. And so together with those factors under the Brown factors, noting, yes, it's a tough burden, it's a hard burden, and noting that, Judge Miller found that Anderson had met those constructive discharge factors under Brown.
Okay, thank you, counsel.
Okay.
You can continue if other. Oh.
Unless you have any other questions, I hope I've answered that. I do agree, and that was one of the biggest points that I wanted to stress with you all today, was whether this idea of going back behind the factual findings by the district court just seemed like it was circumscribed.
Okay, we have that. Thank you, counsel.
All right, thank you, Your Honor. Honors.
The record is undisputed. That as much as Anderson did was say he was not going to be at an event because he was going on vacation. Not that he wasn't going to support the campaign. That he wouldn't buy the brisket, but he'd cook it at the campaign event. Not that he wouldn't support the campaign. So that is why, and as Judge Duncan and I discussed in my opening statement, it is the case that Clark contends that he told Diaz, I'm not going to support your campaign. But as to Anderson, that is why the appellees posited the argument of compelled speech in the district court. And the problem with that is that the law is far from clearly established on whether that is compelled speech. But as to the assertion that O'Hare provides the answer to this question, I would respectfully submit that since this court in Rogers said that O'Hare does not clearly establish the law, and the court's obligation to overcome the presumption of immunity is to fix a case that does clearly establish the law, only under this court's rules in en banc consideration could the court find that the Rogers panel was incorrect and that somehow O'Hare provides the test of whether this case falls within that clearly established law. Let me, if I may, then flip to the issue of adverse employment action. This court takes, quote, a narrow view of what constitutes adverse employment action. That's in the reply brief at page 18, Bro versus Garland. It's an objective analysis. And I heard my friend say that the job was considered by Mr. Anderson to be less desirable. But this court in Alvarado versus Texas Rangers, also cited at page 18 of the reply brief, made clear that the plaintiff must establish upon objective factors that the job assignment causes serious objective and tangible harm, not simply that the personal preference of the individual was not to have that assignment. I won't belabor this except to point out that the appellees tacitly acknowledge that they don't meet that test, because in their brief, the appellees didn't cite evidence of rising to that level. What they did was, and let me find the quote here, what the appellees said in their brief was, I beg your pardon, at page 13, addressing this issue in the appellee's brief, the appellees did not cite evidence, but rather what they said was, Judge Miller, quote, likely drew upon his own law enforcement experience in deciding that this was an adverse employment action. And obviously, I don't think Judge Miller did that. I think Judge Miller simply erred in believing that these were adverse employment actions. And as to Clark, again, since, I beg your pardon, Anderson, because he worked the job for 9 months, I'm sorry, let me get my notes here. Page 5. I must confess, I get Anderson and Clark confused. Anderson never even worked the assignment as night shift promoter. Never took the job at all. That's at record 2248. He simply chose not to take the job, took his vacation time, and resigned from the constable's office, claiming a constructive discharge related to a job he never even took. He certainly acknowledged that contrary to this court's holding in Haley, that Anderson made no attempt to resolve his concerns about that job. The night vision issue is something that Mr. Anderson raised only after he resigned. He admitted that he never provided the county with any documentation showing he had any medical problems with night vision. That's at record 2196. As to Mr. Clark, as I said in my opening statement, Mr. Clark supposedly worked this intolerable assignment for 9 months before joining 12 other people and choosing to be a plaintiff in a lawsuit against Constable Diaz. Under the objective standard that this court applies, that is not retaliatory, that is not actionable. And more importantly, there's no clearly established law that this court could point to that would have told Constable Diaz that those reassignments rise to the level of being in violation of clearly established law. Immunity sometimes goes down hard, I understand. But it is the appellee's burden to disprove the presumption of immunity, and I would respectfully submit that on any of these elements they have not. I appreciate the court's time. Thank you.
Thank you, counsel. That case is